The second case on this morning's docket. That is case number 110318, Doe versus Thompson. Ready for counsel to proceed.
Mr. Chief Justice, and may it please the Court, Assistant Attorney General Christopher Michael Grunwald, on behalf of both appellants in this matter, which I'll collectively refer to as the state, I would ask for 3 minutes of rebuttal time to be reserved.
3 minutes is granted.
Thank you. The state brings this appeal from the District Court's decision that the 2011 amendments to the Kansas Offender Registration Act, which I'll call KORA this morning, are punitive in effect, and the state appeals from the District Court's judgment that applying the amended statute to plaintiff John Doe, who is a sex offender, it amounts to a violation of the ex post facto clause of the United States Constitution. On appeal, the state raised 4 issues. This morning I plan to address only the main issue here, the ex post facto issue. On the remaining issues, we rest on our briefs unless the court has questions.
Well, my question is, if we determine they have merit, for instance, decide the district court should have granted your motion to strike, the remedy would be to remand to redo, wouldn't it?
Your Honor, we believe that there is sufficient, that it is sufficient what's been presented to the court.
But we don't do fact-finding.
Agreed, Your Honor. We do not believe we need to prevail on those points. It's up to this court to decide whether or not this information should not have been in.
But you raised the issues. You raised the issues, and I'm asking you if we agree with you on one of the other issues. Isn't the normal and usual process for us then to remand for a rehearing?
We don't believe that that's necessary in this case. We continue to stand by the argument that even were you to accept the record as it comes to this court and the rulings that the district court did along the way, even accepting those rulings, which we disagree with, even accepting those rulings, we believe this court has enough by looking at the provisions of the statute and determining under the controlling precedent of the United States Supreme Court case Smith v. Doe that the application of the statute is not punitive in effect. It has a public safety purpose, and for those reasons, Doe's claim should fail as a matter of law. And we believe that to be the case regardless of those intermediate rulings.
But you did raise those issues.
We did. We believe
and my question to you is, why does the state care whether this plaintiff proceeds with a pseudonym? Why do you care?
The state raised this issue because we believe that the application of this court's precedent for determining whether it's appropriate to do it, we believe that if those factors were not applied correctly, and we believe that in every case that's brought a constitutional challenge to a statute, the presumption is that those cases will be aired in public. And there has to be good and weighty reasons to not proceed that way, and we don't believe they were met here. And really the guts of the point there is that plaintiff went and filed his action under his real name, and it sat in the record for about 90 days. So you already are behind the 8 ball when it comes to the factors in terms of whether or not it should be public, because it was done in public to begin with. And that's an important factor that we believe the district court didn't apply at all. With respect to the ex post facto issue, it boils down to this. In 2011, the Kansas legislature amended KORA to bring it up to the federal standards in the Adam Walsh Act, and that included extending the registration terms for sex crimes. The Adam Walsh Act establishes 3 tiers for sex crimes, and the registration periods that are established in the Adam Walsh Act are 15 years, 25 years, and life. What that means for plaintiff John Doe here is that he was registering for 10 years because the crime he committed, fondling a 14-year-old girl, is indecent liberties with a minor. And the registration term under the Adam Walsh Act for that crime is now 25 years. So what Doe did is he sued to block two things. He sued to block the obligation to provide law enforcement with his registration information. That's the law enforcement side, the registration branch of CORA. He also sued to do a second thing, which is to prevent public access to the 10 items that are deemed to be public information under CORA of his registration information. That's the public side of CORA, the branch that's known as the public notification branch. What the district court did in this case is cut down both branches of CORA as it applies to John Doe and told him he didn't need to provide his information to law enforcement and that the public would no longer have access to his registration information. I'd like to start
I
with...
just want to clarify that you're not disputing that the Kansas Act goes beyond the requirements of the Adam Walsh Act?
We are not disputing that the Kansas Act includes some provisions that are beyond the Adam Walsh Act. That's correct.
And that Doe versus Smith is not dispositive because of that, at least. For one of many reasons, it may not be dispositive, but that is one.
Doe has certainly argued, and the district court picked up differences or distinctions between the Alaska statute at issue in 2003, in particular, although I don't believe they were focused on the Adam Walsh Act specifically, and considered that to be distinguishable. For the reasons we've argued in a brief, and I'm going to cover briefly here today, we believe that Smith v. Doe continues to be controlling precedent on these issues, in large part because they conceptually have been addressed and dealt with in the Smith v. Doe decision, and there's nothing new as a matter of kind in terms of the changes that were made to the offender registration program. The preliminary points I wanted to set the stage with, one has already been addressed here by Justice Luckert, which is that Smith v. Doe, we believe, is controlling precedent. And I think there's agreement. The district court, John Doe, and the state all agree that the 2003 decision establishes the framework for doing an ex post facto analysis of a sex offender registration and public notification program. The second preliminary point is that, as I've mentioned, there are two branches to this statute. There's a law enforcement side, which is registration, and there's a public side, which is public notification. We believe that it's important to analyze each of these separately when determining whether or not there's an ex post facto violation. And the last point, picking up on the distinction between registration and notification, is at least I would like to emphasize that we need to make sure we look at the situation in 2003 that John Doe was facing. In 2003, when he was convicted of his sex crime, he had to register. He had to provide information to law enforcement. That information, a limited subset of it, was made available to the public. So the question is, what has changed since then? And we'll discuss some of the provisions in detail, but again, the situation as a threshold matter is that in 2003, registration was non-punitive. This court in 1996 in State v. Myers said registration, providing information to law enforcement so they can locate and identify sex offenders, which can be very important to prevent these heinous crimes from happening. But that was non-punitive. It's civil and remedial. If you move from Myers to Smith v. Doe, we again have in 2003 registration, providing information to law enforcement is non-punitive. And that continues right through Kansas precedent. The Kansas Court of Appeals in 2010 in State v. Evans, which we cite in our brief, established or walked through exactly what Myers and Smith together mean. Extending the term, and Evans is directly on point, extending the term of registration is simply extending something that's non-punitive. There is no ex post facto violation. Evans has been cited and relied on by other Kansas Court of Appeals decisions, and in fact, I believe you're hearing arguments in fact, I know you're hearing arguments on the case Boozer later this morning, and in that case, the opinion, the Court of Appeals decision specifically refers to the Evans decision.
Duration was not a part of the calculus of the prior decisions in determining that it was non-punitive.
I'm sorry, I'm not sure I followed the question.
In 2003, it was 10 years, wasn't it? Or I believe it as it applied to Doe in this case, it was 10 years. And the analysis that you're talking about in our prior cases dealt with a specific time period that was shorter than 25 years. Is that right?
When you say your cases, Your Honor, if you're
Yes.
referring to State v. Myers, that's correct.
So in determining that it was non-punitive, was the length of the registration a factor in that determination? And there's a significant difference between 10 years and 25 years. I just What's your understanding of that?
Well, let me backtrack for a moment. And I don't have my copy of State v. Myers in front of me. But there were always sex offenders that were going to be subject to lifetime registration. I believe, in fact, in Smith v. Doe, it was lifetime registration. So I wanted to be clear. I was answering your question with respect to what there was a certain registration term for particular crimes.
Right.
I didn't want to represent that John Doe was required to register for more than 10 years. That's not the case. But it would be wrong to conclude that this court and other courts have not been faced with registration terms longer than 10 years. There have been 15-year terms as well as lifetime terms at issue in many of these cases. Smith v. Doe, again, I believe if you look at it, you're going to see that lifetime registration is at issue. And the courts have all concluded as a matter of federal law, as a matter of the United States Constitution, that categorical classification of sex offenders, requiring them to register for long periods of time based on their particular crimes, does not represent a punitive effect, does not represent a punitive purpose, and for that reason, it doesn't raise ex post facto claims.
And the amendment at issue today, in terms of the registration requirement, didn't expand that requirement in any way other than time.
I want to make sure I understand your question. You're saying, did the Adam Walsh Act only deal with extending the time?
The amendment at issue, the application of the amendment at issue today, did not extend the you're dividing it into registration and the publication or notification. So we're still just on registration. I just want to be clear.
Sure.
That effect of the amendment, the only change in it was to extend the time, not to change the nature of the information that had to be shared, for example. The frequency, the cost, all those other things.
All of those things are at issue in this case, Justice Breyer. And so I didn't mean to, if I was confusing the situation, I apologize. We are only here because the term has been extended. The extension goes to registration, and because registration has been extended, public notification is at issue as well. So I don't mean to present that public notification has not been extended as well, but you have to get,
No,
you can only
I'm
get
not talking
there
about
through.
notification. I'm talking
Understood.
about the nature of the information, the nature of the burden of registration. Has it changed in a way under the amendment other than length of time?
And it has, and we should get right to the
So I'd like
registration.
you to address that as well.
Registration piece, which is the district court centered on a couple of things. And what we've bypassed is the purpose of the statute, and we would urge your court to just simply move past the purpose of the statute. The district court in this case found it was public safety. Although the appellee raises in his response brief to reverse the district court on that point, he didn't cross appeal. We believe that's been waived. In any case, there's no reason to question the public safety purpose here.
Well,
so
I'm going to question it. Do we have, was there any evidence presented before the district court? One of the Mendoza-Martinez factors is rational connection to a non-punitive purpose, and that non-punitive purpose has been designated public safety. Do we have any expert testimony or any evidence to support that purpose other than, oh, we just all know it's that way? It seems to me it's always been we know that, as a matter of common sense. But was there anything beyond that?
What I can direct Your Honor to is that in the record, and this was actually material the plaintiff had submitted in support of summary judgment, you can find statements that were presented at the legislative hearings with respect to the 2011 amendments. That's the recent changes that Doe decided to challenge at the outset. And I'll point you to pages 645 to 650 of the record. And in there you'll see statements submitted by the Kansas Bureau of Investigation explaining the different changes and how they related to the necessity to do effective sex offender registration or effective public notification or comply with the standards in the Adam Walsh Act. It walks through all that. So I would say there's that initial evidence in the record if you need it. We don't think that you need to go very far, though, because all this is tinkering with an existing program. And this court and all the Court of Appeals decisions have always held that the Offender Registration Act has a public safety purpose. And this is simply consistent with that structure and consistent with the plan in terms of making sure law enforcement know the information and that the public has it as well. And the purpose is to get it into these people's hands so they can make good decisions. And so nothing in the current amendments is any different from that. Getting to Justice Byers' question on what's different for registration, the things that were trotted out by the district court include having to register in person, having to pay a $20 fee, the fact that failure to register has a higher penalty, and that there's a longer duration. I'm going to take them in reverse order because I think you can get rid of several of them quickly. The extended duration, as I've already discussed, it's not a thing unto itself. It's either punitive and you do it for longer, or it's non-punitive and you do it for longer. So we're really
I
talking
don't
about...
understand that. If we look at the Mendoza factors, the rational connection to a non-punitive purpose, you have to connect the registration to the public safety, and to do that, you have to show that that long period of supervision accomplishes or is germane to that non-punitive purpose, don't you?
I think that's easily shown here. I think it's shown...
Well, but that isn't what you said. You said the duration is not relevant. And I'm saying that the duration is relevant when you look at whether the non-punitive purpose it has a connection to the length of registration requirement. You understand what I'm asking?
I think I understand your question. Our position on appeal is that duration by itself is not count. But I understand your question. If your Honor is not satisfied with that and thinks that there's a question about the connection, this is really a question about recidivism. And if you want to get to recidivism, you need only look at John Doe and the record that he's brought forth, which is that he admitted that he fondled a 14-year-old 17 to 18 years earlier than the crime he was caught for. There's no question that sex offenders recidivate. That's not actually even suggested by them. They don't say it's zero. And if you're looking for recidivism, you can either go to the statistics in the brief that they've submitted, and they have a study citing that suggests that 73% don't recidivate. Well, that means 27% do, and that's 1 in 4, and that seems pretty high. They have other statistics they trot out with lower numbers. And if this court is interested in going to those numbers, there are a couple of important caveats, which are, we're talking about sex crimes, and it was entirely legitimate for the legislature to be very concerned about these heinous crimes and to treat them differently. We're not talking about shoplifter recidivism, and you can't make an apples to oranges comparison on those figures. And we believe the record has already established that the concern is legitimate. I'll briefly try and address the fee and the in-person reporting. The penalty simply isn't at issue for the reasons we explained in our brief. The fee is not punitive based on the application of the Court of Appeals precedent and the fact that it is dedicated in the statute to go to a separate fund to cover the costs of the program, and there are costs. Law enforcement officers and civilians have to spend time collecting the information, managing the database, and accomplishing all the tasks that are required for the program. And those are not punitive by themselves. And we believe it's clear. You can look at the Mueller decision, which we submitted as persuasive authority in our additional authority letter, showing that a $100 fee per year is not per se unreasonable. And there was no evidence, just as there's no evidence here, that the costs of the program exceed that. On the in-person registration, if I might briefly address Justice Byers' question.
Certainly.
Thank you. This is not an affirmative restraint. Affirmative restraints are things like residential restrictions, preventing you from traveling, moving, living somewhere, working. That's not what this is. Doe makes the argument this is like probation. It's not. Probation and parole impose conditions, where you can work, where you can live, who you can associate with. That's not what's at issue here. There's no limit on movement. And the sex offenders having to show up in person serves an important goal, which is making sure that there's current information, physical descriptions, photographs are updated, and they're confirming the location of the register, the sex offender in the jurisdiction. And for those reasons, we think that, and if you want to look for analysis of this under the federal Constitution, all of the federal courts, circuit courts of appeals to address this issue have all concluded in-person reporting is inconvenient. It is an imposition on time. You can even look in the Smith v. Doe decision. An imposition of time is not the same as affirmative restraint. I see my time has expired, and I'll reserve other comments for rebuttal unless there are other questions.
Any more questions?
I have one. Tell me if I'm wrong in the way I'm looking at this. It's a federal question, so we look to federal law. We have the Alaska decision. So really, the only thing left for us to do is to decide those differences between the current Kansas statute and the Alaska statute that was upheld, and see whether those differences tip the balance. Is there any other way to look at this in your view?
That sounds correct. And the question is whether or not any of those differences that have been
Right.
relied on amount to a substantial change. And for the reasons that we've discussed and we've argued, we think not.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Chris Joseph on behalf of Appellee Mr. Doe. And if I may, I would like to start with Justice Biles' question.
Great, because I was just going to re-ask it.
Okay. I don't think that's the right analysis. That is one of the factors the court look at. You look at the difference between the law, but this court is challenged with evaluating the effect of today's law on today's offenders, not what happened in 2003. The context is what's critical for evaluating the effect of CORA today. And that requires not only looking at...
And how do we do that? How do we do that when we have pretty explicit precedent that says the U.S. Supreme Court's interpretation of the United States Constitution is binding on the states?
Because Smith v. Doe is simply not controlling. It was decided in 2003 in an era before there was any connectivity with the internet, where the internet had not transformed to where it is today, where social
But
science...
how do we change it? How do we fix it to be modern when we don't have the authority to overrule?
You're not overruling. You're not overruling. You're distinguishing. You're taking a fresh look today. Because Smith v. Doe was decided in a day when it was decided that public notification constituted an official visit to the archives of the criminal record. We know that's not true. If you Google a name today without looking for offender registration information, it comes up. The sheriff's website links to social media sites that allows commentary that broadcasts it widely so that people who are not looking for this information encounter it. The FBI has in their website the community notification tool, which broadcasts emails. There's for-profit companies that have it on the internet. It is not what Smith v. Doe described. The world has changed dramatically since 2003 when Smith v. Doe was decided. There weren't smartphones then. Dial-up internet connections were dominant. The court is being asked not to overrule Smith v. Doe, not at all. The court is being asked to do what the Supreme Court would do today, take a fresh look.
Do you think John Roberts would think that way since he argued the Alaska case and won?
Well, without speaking and predicting what individual justice would say, I think on the whole the Supreme Court would look at it again today and would consider the environment and the context. They relied, Smith v. Doe, if you go through Smith v. Doe, and I did, and I made 9 points where the science, the statements, the facts, which were the basis of it, just aren't true anymore. They relied on 1997 studies that were incomplete and have now been discredited for the rational connection and the excessiveness analysis. It's just wrong now. We now have a consensus that the authors of the Static 99, which I like that study quite a bit, because that is the tool that is considered the gold standard for predicting offender recidivism. Now we know, based on that science, that you should focus the efforts on the first years, and that after 10 years of offense-free in the community, recidivism risk goes down to 1% or less.
Does the pursuit of that issue require a deeper trial on the social science then and now? A deeper trial than what you had below?
It does not. It requires doing what this court has done historically, such as in considering the correlation between eyewitness identification certainty and eyewitness identification reliability. It considers doing what the court did in Smith v. Doe when there was no expert testimony. If you look at all of these cases, there was not a single case that involved expert testimony. The courts did what courts do in deciding constitutional issues. You look at the science, you look at the world around You look at the amicus briefs. Smith v. Doe just pulled, the Supreme Court pulled those 97 studies. They looked at the world around it. That is what is the difference between the adjudicative and legislative facts. We don't have experts because an expert is required to take scientific principles, these legislative facts, and then apply them to the individual defendants, to the adjudicative facts of this case. Here, what would our expert do? Read the surveys, read the studies? That's something a court can do. That's what every court to address this issue that's done in-depth analysis has done. Now, the federal courts that you're talking about that have been referenced, the courts of appeals following Smith v. Doe, they don't do that, which is why their analysis should be not considered to be terribly persuasive. They simply parrot Smith v. Doe, and they do not look at the changes in society. They do not look at the fact that Smith v. Doe is premised on what is now repudiated and clearly not true science. It's a 97 study that says, well, sex offenders are really high risk, 56% or so. Turns out that was a high-risk study that was predictive, and it didn't address offender recidivation. We now know that notification is not effective, that actually may increase recidivism, that registration is not particularly effective. We know the risk factors, which, by the way, are not what CORE is based on. Risk factors are not the crime of conviction, and we now know that the risk of recidivism is at the front end, and then after 10 years in the community offense-free, risk factors go down dramatically.
You say now we know.
That's the
with
consensus.
a great amount of certainty, and following up with Justice Biles, how do we know? I mean, that's your take. I assume at a hearing where facts can be taken and evidence taken that there'll be two sides to what we know. And then a finding about what we know, and then we would review what we know. Wouldn't that be, rather than you coming up espousing this is what we know?
You do what every court to ever have addressed this issue does, which is not that. No court has done that. If you look at what Judge Hendricks did, he did exactly what's expected. You read the social science. In fact, he ruled against us on some points by reading the social science. He did what the United States Supreme Court did in Smith v. Doe, which is read the social science independently and reach its own conclusion. The way, if you read the legislative fact discussions, there's advocacy, there's articles suggesting that the better way to present this to the court is not in a hearing, because then you just have a live presentation, but the better way to do this is through briefing. Parties cite, parties disagree. In fact, the defendants, in their most recent response to the amicus brief on page 4, now acknowledge that you can do just that. They cite Brown versus Board of Education as an example. They cite something that was in dispute, and that is what happened.
Isn't the difficulty with that the federal statute, judicial notice statute specifically exempts legislative materials, and Kansas is silent in that?
Kansas is silent. Yes, Kansas is silent. Kansas does not respond to it. And you have different interpretations as to how it's ambiguous because it's silent. So you either accept what Judge Liebman interprets it, or you accept what the treatises, all the treatises say you should do it. It's not part of what you would consider the rules of evidence. The rules of evidence apply to adjudicative facts, what happened to this individual, what happened in this case. They don't apply in constitutional law cases to broad principles and what the nature of society is. That's the consensus among the treatises. And that's why it seems to me that in response to reply to the amicus, the defendants agree. There are instances in which the court may look to outside factual sources to inform the decisions, and even cite Brown versus Board of Education, which, by the way, there wasn't a hearing in that in terms of what the psychological effect on the impact of racial segregation was. That was the court pulling from the social science.
No, it was the court pulling from evidence that was heard in evidence here and heard in other trial courts. I don't want to get into Brown v. Board, but they clearly had evidence that was developed at the trial court. That's what those cases were about.
Okay. Well,
go ahead.
The position is this. You can either require us to go get an expert that will read the studies to the judge, and they get an expert to read the studies to the judge, or the judge can read the studies themselves. And that is historically what I believe has been done, and that is the proper way to do it. If you remand, the remand effect will be that we'll get an expert to go read the studies to the judge, and the judge will presumably reach the same conclusion. I would suggest that that's not good policy, and that's not a proper interpretation of the law. It is ambiguous. It does not say you must do that. And the consensus among the treatise writers and those who are brighter than I am about rules of evidence is that that's not how you deal with these types of facts, because what you end up with is experts reading the studies. These are studies that don't need interpretation. These are studies that don't need someone to say, here's what it means, because you can read it.
Your position would be that even if Cora had the same provisions as the Alaska statute did in 2003, that the statute would still be vulnerable to attack because we know something different today than we knew then.
Absolutely, and that is in fact the case. It's explained in the legislative research or the legislative fact analysis, is that you always come back and revisit it. In fact, examples from the Smith v. Doe, which are the rationale that they relied on. Not only did they rely on the 97 study, they relied on the idea that the way that public notification works is you have to go to this site. That's the only way you can get it. It's akin to a visit to the archives of criminal history. It said that there was no evidence of any occupational or housing disability, that was pure conjecture, and that the principal effect was not shame and ostracism. Well, we now know differently. And much like the United States Supreme Court, through their own rules of evidence can consider that, they revisit that. Their analysis is changed based on the way society's evolved, the way that we connect to the internet, the way we use the internet, the way notification functions in the internet. That plus the fact that Smith v. Doe relied on 97 studies that were impartial, incomplete, and now repudiated, or at least the consensus, if you read the science. Now, this court is free to read the social science and say, we disagree with you, Mr. Joseph. We think that's not true. We think that there is a rational connection. We think it's there. You can do that. That's exactly what Judge Hendricks did to us on one point. He said we disagree.
Every time you talk about the change in circumstances, you mention the internet. Do you agree that the state's position seems to be that we can silo our analysis, one being law enforcement and the other being notification, which made sense to me? Would there be first of all, do you agree that we can look at each separately on the constitutionality question? And then if so, what is it about the law enforcement side of the world that tips the balance and makes this unconstitutional? So there's two questions.
Yeah. Well, I agree that in Myers this court did that, so there's certainly some precedent to it. I would suggest you read it as a body as a whole. However, it is certainly, there's some precedent for doing that. And if we're going to look at the Mendoza-Martinez factors for just registration, which I will do at this point, it is still punitive, just as Judge Hendricks found. The issue for rational relationship and excessiveness, we now know that the lengthy registration periods of the 2011 amendments don't fit. Recidivism rates are less than 1% after 10 years for offense-free in the community. We now know that there's specific risk factors, and it isn't the offense of conviction. We now know that Cora opposes affirmative disabilities and restraints. At the very least, you're physically in person somewhere 5 days a year, 4 times for registration and 1 time for your driver's license. Every time you go somewhere for a vacation, if you go to another county for school or work, that's additional in person. You've got to physically be there. I simply disagree with the idea that that's just an inconvenience. That's a restraint. That's telling you where to be. Furthermore, it is comparable to supervision of probation and parole. Now, while it's true that probation and parole often requires probation and parole require 2 elements. One is monitoring, making sure you're doing okay, making sure you're doing things and following you. And there are some additional affirmative requirements, but I'll tell you what, probation and parole for life, well, probation for life is unheard of. I know there's some circumstances where you can do parole for life, but it is the idea of having probation for 36 months under the guidelines with some additional requirements, or these requirements for 15 to 25 to 30 years life, makes it punitive in the sense that it is comparable. Public notification, we now know, creates obstacles to housing and employment. That's not conjecture, as the Supreme Court said in Smith v. Doe. We now know it's not conjecture, and I will suggest that substantial registration fees are punitive. Now, Judge Posner says, well, the point of it is to reimburse. We are doing Mendoza-Martinez factor analysis, and that means we look at the effect. It doesn't matter if the purpose is to reimburse, it's the matter of the effect. And somebody that's lacking employment, especially Mr. Redmond, the next gentleman up on the case, the next case up, you will see that that is difficult. That's punitive for somebody to have to come up, with somebody who can't find employment, to have to come up with that amount. I would agree also that sanctions are now historically regarded as punishment. Not only is it like probation and parole, but a lot of Smith v. Doe's analysis and other analysis says, hey, you used to make somebody go to the town square and wear a sign, and that was bad. Today's town square is the internet. Today's town square is the internet. That is the most damaging forum available. Mr. Doe would much rather stand in Crown Center than to be displayed across the globe on the internet for 15 years. Today's town forum is the internet. And that is something that society, or this court must recognize and change the societies, that it is comparable to shaming, to humiliation. It's out there. It's in social media. It's in your face, whether or not you look for it. Even if you don't look for it, if you look for just an individual, boom, the registration information comes up.
You indicated that we should distinguish Smith versus Doe because the social science upon which it relied is outdated.
Correct.
My reading of State versus Myers, where this court found that the notification portion was unconstitutional, didn't rely on any social science.
Correct.
That I could see. So under your analysis, that's really not valid. That decision is outdated also.
No, if you see a section in my brief, which I'm not talking about, and I'll switch to talking about right now, there's a section in my brief that says, look, you don't even have to rely on the social science. You can use this court's experience. You can use Mr. Doe's experience. You can use the experience noted in State v. Meyer, and you can use logic and common sense. I mean, if you're broadcasting for everybody's knowledge that somebody's a registered offender with this criminal history, which, by the way, is selected.
Well, let me go at this a different way.
Go ahead.
Myers' determination of the notification segment being unconstitutional was before Smith v. Doe.
True.
How do we get around Smith v. Doe invalidated that rationale in Myers?
Different laws, different sets of facts, and the rationale in Meyer was not repudiated in Smith v. Doe. In fact, the rationale in Myers was it makes common sense that you're going to cause problems for somebody's employment. It's going to cause affirmative disabilities and restraints. You're going to humiliate and ostracize, and guess what? That seems to be happening. Smith v. Doe didn't say anything to the contrary. They cited a 97 study that says recidivism rates are high.
State versus Myers talked about the practical effect of the public disclosure was that it would make it impossible for the offender to find housing or employment. I read Smith versus Doe as directly addressing that, saying that's just speculation.
Correct. They said it's conjecture, and now social science says it's not conjecture. There's even the Tewksbury from 2009 did a survey in-person interview for Kansas and Oklahoma. We know it's not conjecture. That's another problem with Smith v. Doe.
But let's put on your lawyer hat. We decide a case based on federal constitutional law. Mm-hmm. The United States Supreme Court decides a case and finds differently. Finds that the rationale that we used is not appropriate or it's not good enough. It doesn't make it unconstitutional. How do we get back to our case without saying the United States Supreme Court was just wrong, and we don't agree with their ruling? And how do we do that given mandatory precedent?
You simply revisit the subject under new circumstances, which is exactly what Judge Hendricks did. There's new law, there's new knowledge, there's new facts, and you revisit the subject, suggesting that the United States Supreme Court would reach a different conclusion, suggesting that the facts before the Smith v. Doe court are different than the facts before the court today, and it's time to revisit it.
Usually we have to be able to say that we're firmly convinced the higher court is going in a different direction. What can you tell me that we can use to to be convinced of that.
Without doing individual analysis of justices, which I've done, and I don't think that's appropriate for your opinion, you can point to, for example, the Justice Souter concurrence. Justice Souter, which made it 5-4 one way as opposed to 5-4 the other way, said, boy, this is a close call, and I'm only going on the fact of the presumption of constitutionality because there are certain things that weren't present there that are present today. The analysis has changed, the facts before the court are different.
What about the
He's
reason-
not there either.
Correct. Right. And so predicting what the court would do is difficult. All I can say is that what you should do, what I think the appropriate analysis is not predicting individual justices, but saying, hey, the issue today, the law today, what we know about the world today is so dramatically different than Smith v. Doe that we believe that they would reach a different conclusion. And I think that's fair to say. I really do.
I didn't mean to cut you off, Justice Johnson.
The recent decision about searching smartphones, what does that tell us?
Well, you know, when Smith v. Doe was decided, there was no such thing. The
Well,
iPhone came
I
out
understand,
7 years
but
later.
what we're looking for is some indication of an acknowledgement by the U.S. Supreme Court
Right.
that the world is different. I mean, we have to be able to say that they would acknowledge that.
Yeah,
Don't we?
I think that is certainly one example, and without going through individual precedent, but there are written, published decisions that you were including the smartphone, the acknowledgement that the internet and the connectivity and what is in the phone is like a library now compared to the no texting phones of 2003 is one. But I simply think that you can look through the Smith v. Doe factors, the Smith v. Doe court rationale, and look at the things that just aren't true anymore.
What is the purpose of the notification aspect of this amendment or the statute?
The purpose of it,
The notification?
I'm not going to say that the legislator acted with a punitive effect. What we're arguing there is that it should not be given great deference. What we're analyzing...
But isn't the basic purpose is to notify the public of the status of this individual?
The purpose that Myers found is that it was to advance public safety. So yeah, it is to get it out there and to get it...
And then why isn't the internet just a more effective and efficient way of achieving that purpose?
Well, in Smith v. Doe, they looked at the limited scope and said because it is like an official visit to the archives, it doesn't cross that bridge to become punitive in effect. So, you know, it is effective for dissemination, and there is a line where at what point does it become punitive? At what point do you receive the information?
There's too much notification?
Everybody, yes. I mean, the point at which it is in everybody's face without... Smith v. Doe said you had to go affirmatively to this archive, this online archive, to find this. You had to seek it out. It wasn't in your face, and that was important to say that it was not excessive, that it met the public safety. Now, when you're doing the analysis today of excessiveness, you don't even have to look for it. It's right there, boom, in your face, without even looking for it. And that makes it considerably different. The issue today, though, is the effect.
Well, there's a difference, isn't there? I mean, you do have to look for it. You have to be looking for information about an individual.
Well, you either A, have to look for information about an individual, or B, be on social media. Just being on social media, when neighbors, friends, and families use the sheriff's website or otherwise link and blast comments and information and picture, you encounter it without looking for it. It's out there on the internet. You don't even have to look for the individual anymore. But yeah, I mean, without looking for registration information, if you look something about an individual, you find it. But furthermore, because of the way social media is, and I think it's
Right.
disingenuous to say that the sheriff's link to that doesn't encourage it.
But the point, I think, is, wouldn't it be that to have an effect, that person who has received that information must know the person who is registered. Otherwise, there's no effect.
Well, presumably, yeah.
And,
I mean, that they're talking
aren't
about
those
neighbors.
the people we want to provide the notice to, or those who might be having an interaction at some level with that registered individual?
Yeah, what you're looking at is the rationale or the basis for it, which was stranger danger, which has also been kind of which has definitely been repudiated. I mean, yeah, if you broadcast, and CJ Online, for example, and this goes into the shaming, they put out now folks in the community. They list them online. You can go through and browse everybody and their information and comment about them underline. I mean, that is where you get towards the punitive fact. Not only is it there, but when you tweet someone, You're not just tweeting the objective information, you're tweeting with commentary. When you put them on Facebook, you're putting it with commentary. When CJ Online runs, like many newspapers runs, here's everybody in Topeka that's a registered offender, their pictures, their information, their details. There's comments for users to put out there. That is what moves it further into the shaming and the ostracism that the Smith v. Doe court said, no, that's not what you have, because you got to go to this official archive and look for it, seek it out. It's not just out there and there's no commentary available. Society is different today, and that's why the Supreme Court would change their mind about Smith v. Doe. It's just different. The rationale's wrong.
Do we have any further questions?
Chief, just one
Yes.
question. Mr. Joseph, earlier you were wanting to talk about the selectivity of the criminal history, and I'd just like to hear your just brief thoughts on that, please.
Okay. Well, I would again point to Justice Souter and his concurrence. Justice Souter says the purpose of this is to broadcast something that otherwise wouldn't be heard and about a specific group. A specific group that you're sending a message. The selectivity, it's not all convictions, it's not all felons. It's a specific group, and that sends a message that creates ostracism, that creates fear, and that is a very important factor that Justice Souter and many of the justices were considering at the time, and I think that that's different today when you have public commentary. I mean, it just takes it to a whole nother level. The internet just changes it. Not only do you have selectivity, but you have the commentary. It sends a powerful message. We now know it affects housing and employment because of what Justice Souter saw. We now know the things that this court predicted in Myers have come true.
Thank you, counsel. You're reserved 3 minutes for rebuttal.
Thank you, Mr. Chief Justice. I would like to try and cover 4 points. We'll see if that covers the court's questions as well. I'll begin with what we just heard about, a fresh look. And we're talking about the public notification provisions now, which is something I didn't spend a whole lot of time on, but we've discussed here already. And the public notification provisions, it's important for this court to look. There are no new statutory provisions here that are being identified that are distinguishing this from before. Now, that's important because it's the statute that this court needs to be analyzing to figure out what went too far. Well, if you want to look inside the statute and cross out accessing Google or posting to Facebook or allowing shaming comments, you're not going to find that in the statute, and that's because it's not there. I'd urge you to be very careful about the district court opinion. The district court opinion makes a statement that is wrong and not supported by the record, and it says that the Johnson County website allows shaming comments. That's not true. There's no record site for that statement in the district court opinion on page 19. If you go to the facts section of the opinion, it's not explained that the Johnson County website does that. And if you look at the record, it doesn't do that. All that we're really talking about are these tools for sharing. That's not in the statutory provisions, but let's go ahead and talk about what happens. What happens is these are links to third-party websites. To hear the arguments, basically John Doe wants to shut down the ability for other people to take public information, the conviction is public, and say things about it. That has nothing to do with the Offender Registration Act. You can't control that, and you can't censor other people through this statute.
I don't think that's a fair analogy, because really what we're talking about is law enforcement or a government entity facilitating that sort of notification. It's not prohibiting anybody from sharing anything. They just have to take a couple of extra click steps.
And I think that even if this court is looking at what happens in the real world, I wanted to get to, and this relates, I believe, to your point, the supposed consensus out there that the world has changed. There's a brick wall, which is Smith v. Doe, to get through conceptually. Smith v. Doe, in that opinion, assumed that there was ostracism. It assumed that it was very bad, and assumed that there could be very bad job and housing consequences. And so this idea of facilitating what goes on, it again, in Smith v. Doe, is about the communication of public information. You're having problems because you're a convicted felon, and you're having problems because you were convicted of a sex crime. And again, the consensus, supposedly these articles that are cited, show that this is actually happening because of the registry. That's not true. We'd urge you to read the articles if you have to, and you can see that these are just taking self-serving, self-reported answers from sex offenders that are not very happy with the registration.
Well, why do we,
statute.
if the conviction itself is sufficient to notify everyone of this circumstance, why do we have the registration? I mean, if this is caused because they were convicted of their inability to get housing or their problems with employment, if that was all caused because of the conviction, then what's the purpose of the registration?
The purpose of the registration is to protect public safety. What we don't want is another Megan Kanka, a 7-year-old girl who was sexually assaulted and murdered for a sex offender that was living next door. We want parents to make informed decisions about their children and protect them, and that can be done through broadcasting.
I don't think you understood my question. My question is, if these problems are not caused by registration, then what was the purpose of registration? The purpose of registration is to get that information out there, and because the information is disseminated, that's what causes, not the initial conviction.
I'm not sure I understand your question fully.
Well, let me ask you, did you say that the problems Doe was having emanated from his conviction, not from his registration? Or did I misunderstand what
That's
you
true.
said? And I'm asking you, if that's true, if the conviction itself would be effective to cause him all these problems, why do you need the registration? You need the registration to disseminate the information.
And I think that's a conflating of whatever problems that John Doe is complaining about with the purpose of the statute. Because the purpose of the statute, I would not want this court to think the purpose of the statute is to cause employment problems or housing problems. And in Kansas, there are no residential restrictions for sex offenders. That doesn't exist. There's no redlining that goes on here. Those may be collateral consequences. If you have to fill out a job application and you have to say convicted felon, and that's the reason. And if you look at one of these articles, there's a survey respondent saying, I usually never get past saying I'm a convicted felon. That's not because he's a registered sex offender. All of these things are objectively verifiable events. Did you get a job rejection? Were you evicted? Did you get a housing application rejected? Nobody attempted to verify that any of that's true. So if this court was going to look at those studies, they really need to look at them very skeptically. On the Facebook, this idea of connecting to Facebook and broadcasting, which I believe goes to several questions that have come up here. If the purpose is notification, it makes sense to allow the rest of the world as it exists now to be used. If sex offenders have access to children through social media, we would only, of course, want parents to also be getting information through those same outlets. Again, this is not statutorily mandated, but if it is happening, it only makes sense that it's happening in both ways. I guess a final point on selectivity. Again, we're not dealing with shoplifters here, we're dealing with sex offenders. And the Autumn-Walsh Act does create 3 tiers for lengths of registration and classifying different crimes having longer terms for registration. So there is some selectivity going on even within this. I would finally conclude by reminding us all that there's a weighty burden that has to be met by a plaintiff seeking to overturn a statute on constitutional grounds. We don't feel that was met here on either prong. And for all the reasons that we've discussed here and in our briefs, we respectfully request that this court reverse the judgment of the district court. And because it is a failure of John Doe's claim as a matter of law, we request that the district court be directed to enter judgment in favor of the state. Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.